Lordship, may I seek indulgence in respect with item number 1 and 2 of daily course list?
Today's course list.
Yes.
Yes.
Daily list for admission item 1 and 2.
Okay, Lordship. May I seek indulgence in respect with this item? Because my senior Subhas Kayal is out of station, so if the matter may be come up on 8th of next month, he can be present physically.
It's a fixed item, Your Lordship.
Yeah.
Why is it fixed? For?
Because the counsel for the respondent, since he's coming from Guwahati, he was given the choice to select his own date of his convenience. Accordingly, this today was selected by him, and now he is absent.
Who?
My name is Thangram Shah.
Who is supposed to come?
Kayal.
Huh?
Subhas Kayal.
Mr. S.C. Kayal.
S.C. Kayal, yeah.
He has letter of absence till 21st.
Yes.
Okay, what to do? He is the one who is to be heard now, isn't it? Otherwise, this is fixed only for admission, is it not?
No, Your Lordship. Today, in the last court day, Mr. Kayal was instructed, specific instruction was given, as reflected in the court order, to obtain instructions from the Home Secretary regarding compliance of the judgment and order.
Okay.
So in the instant case, Your Lordship, what happened is that the judgment and order has attained finality, and they have neither challenged the judgment and order or the verification report which they are disputing as in the contempt petition. They have not filed anything, and yet they are not complying. And this has been dragging on since 2014, more than 10 years.
Are there similar other matters?
1 and 2, it relates to the same location, that's why it's been clubbed together.
Okay. There is one respondent in respect of whom ID card has not yet come back, that is,
That would be in item 1, Your Lordship.
yes,
This one number 16.
16. Who is 16? Is he an essential respondent?
Home Secretary.
Okay. But somebody is already. It says Mr. S.C. Kyle has filed wakalatnama to represent the said respondent, number 16. So we need not wait for a AD card.
Yes, Your Lordship. He already has instructions.
Okay. So when do we want? 8.
8, Lordship.
But learned counsel for the petitioner. It is submitted that Mr. S.C. Kyle, learned counsel representing the respondent number 6 was
16.
was required to obtain instructions from the said respondent, that is Home Secretary, Union of India.
Union of India.
Yeah. Full stop. However, it is submitted that Mr. KL, SCKL, is under letter of absence until 21st of August, and accordingly prayer has been made for listing the matter on 8th of September. Prayer is allowed on that day. Instructions from respondent number 16 shall be submitted without fail. You communicate the order.
Wait, please, Your Lordship. My Lord, in item number 2, the same order may be passed, but instead of 16, it will be 15.
Okay.
Obliged, Your Lordship.
Item 3.
Please, Your Lordship. My Lord, as seen from the office note, service upon respondent number 7 has not returned till date. So if service report may be awaited.
As prayed for by learned counsel for the petitioner, await report of service in respect of respondent number 7. List after 3 weeks.
3 weeks. Obliged.
Item 4.
Lordship, I have received the instructions from the respondents number 1 to 6, and I may be allowed to file the affidavit in opposition within this week, Lordship. I'll be filing.
My lords, ample number of opportunity was given, my lords.
That was pre-instruction or post-instruction? Anyway, heard learned counsel for the petitioner. It is submitted on behalf of respondents number
1 to 6.
1 to 6 that instructions has been received, and accordingly prayer is made for time to file affidavit. Full stop prayer is allowed. List the matter.
My lords, we
On?
kindly list it after 1 week. It's a covered matter now.
All right, on.
My lords, specific date. If your lordships may have it on 21st, Thursday. 21st, next Thursday, my lords.
21st.
21st of August.
21st
Sorry,
is day
I'm
after.
on 28th.
28 August. In the meantime, respondents to file their affidavit in opposition.
Your lordships may also kindly, my lords, if your lordships may say, last and final opportunity, my lords.
I'll be filing, Lordship, because
My
I've
lord,
already
this has
received
been-
instructions.
This has been
Obviously,
the
I'll
only-
be filing.
This has been the only instruction my learned friend has been getting. They'll be filing.
That now he has the instruction.
Yes, I have received instruction. I'll be filing within this week.
As your lordships.
All right, we take your word for it.
Item 5.
My Lord, though I am submitting my leave of absence, I am appearing today. I am submitting my leave of absence, but I am appearing. This afternoon, I am going out of station because of that. I am submitting my leave of absence.
You have submitted letter of absence, but you are present. Is that what you say?
This afternoon, I am going out
From
for
19.
other station. Yeah,
Now, what do you want today?
my Lord, I have received only the affidavit from respondent number 4, and the rest I haven't received.
My Lord, I'm appearing for the respondent number 4. I have filed my affidavit in opposition on 8/8. File law.
Respondent 1 to 3, 5 and 6 haven't submitted affidavit in opposition.
What about other respondents? Any affidavit filed? Not yet, I think.
The state,
Not yet, my Lord, if may be granted 2 weeks time, my Lord.
This is writ petition criminal. All right. Had Miss so-and-so learned counsel for the petitioner. You want to file reply? What? No. Today affidavit in opposition? No. Respondent number 4 has filed
I may
affidavit in
want to
opposition.
file a rejoinder affidavit.
All right. Also heard Mr. So-and-so appearing for respondent number 4 and learned government advocate for the remaining state respondents. Affidavit in opposition has already been submitted on behalf of respondent number 4. Learned counsel for petitioner prays for time to file an affidavit in reply. Prayer is allowed. Learned government advocate also prays for time to file affidavit in opposition. Prayer is allowed. Release the matter after 3 weeks. In the meantime, the aforesaid affidavits will be filed by the concerned parties.
Obliged.
Much obliged.
Item 6.
Please, Your Lordship, I represent respondent number 4, and I am filing the show cause reply affidavit as we speak, Your Lordship, today.
What about other respondents?
Your Lordship, as per the order dated 11/3/2025, at this stage only respondent number 4 notice may be issued only in respect of respondent number 4.
The notice has already been issued, I think.
Yeah.
Otherwise, how is he come?
Notice was issued only in respect
Only to
of
respondent number
yes,
4.
respondent number 4.
Heard learned counsel for the petitioner. Mrs. Mary Kiante entered appearance on behalf of respondent number 4 by filing wakalatnama and prays for time and submits that affidavit in opposition will be submitted in the course of the day.
Yes, Your Lordship.
Prayer is allowed. List the matter after 1 week.
You're obliged.
Item 7.
This is a contempt petition. As per the office noting, notice on respondent number 1 is complete. 2 and 3 is still incomplete. None appears on behalf of the respondent number 1.
But about 1 has been served.
1 has been served.
3 and 2.
2 and 3 are unserved notice has come back from the respondent number 3, I think.
So what to do?
Your Worship, since we can take fresh steps on respondents 2 and 3, but 1 I believe is complete. Your Worship.
Heard learned counsel for the petitioner. Respondent number 1 has been served, but none appears on behalf of the said respondent. Unserved notice from respondent number 3 has been returned without postal remark, and neither AD card nor unserved notice has returned from respondent number 2, as per office note, full stop. Para petitioner to take fresh steps on the said respondents by registered AD. List after 4 weeks.
Your Worship, just in case the respondent number 1 does not appear on the next court date, then necessary orders may be issued.
That will see
Personal
if it
appearance
is
also.
possible.
Yes.
You can make that submission on that day also.
Okay.
Item 8.
My Lord, order dated 24/7/2025 had passed that this matter is intended to send for the mediation, and In the order, para number 7, how may I read out, my lord? Order 24/7/2025, para number 7. The government advocate he has to be taken instruction from the government.
My lord, the government advocate is on legs in the other court. If this item 8, 9 and 10 may be passed over for the time being, my lord.
Timing.
For orders, item 11.
Lordship, this case was released yesterday, and Lordship had given us a chance whether this section 4192 a petition under section 4192, this is appeal provision, can be treated as the revision petition or not, Lordship. And Lordship, before coming to this,
BNSS.
we take Lordship to the impugned order, Lordship, which is at impugned order is at page F, next to the appeal, next to the index, Your Lordship. The operative is from page F.
Impugned order dated 4/7/24.
4/7/24, Lordship.
Yes.
Page F, paragraph number 6.
Having perused.
Lordship, yes. I may read, Lordship. Having perused the complaint sheet and its annexure, and upon hearing the rival counsels, the following discrepancies and irregularities were found. Number 1, the prior information received by the customs preventive post at selling was reduced in writing. However, the same is not submitted to the superior officer till date. Your Lordship, that is the one of the reasons taken by the learned special court for discharging the accused, Your Lordship. And however, this information in writing has been annexed and enclosed in the final complaint, Your Lordship. That was page 33, Your Lordship. Page 33.
Now, first let us resolve the question.
Correct.
Lordship,
Or
yes.
are we going to merits now?
Correct.
And the other grounds taken by the learned trial court was everything was available in the charge sheet, Lordship. That was,
All right.
I suppose that there was a mistake on the part of the trial court, Lordship. So, and regarding that, Lordship, whether this can be treated or not, there's one citation, Lordship, which I would like to rely upon.
Copy. Well, this citation copy have not been provided. If I could be given the
Lordship, this is the Madhya Pradesh High Court, Your Lordship. The operative is from paragraph number 7, Your Lordship.
My lords, before my learned friend begins, if I may just be given the citation at least.
Yes.
Copy have not been given.
Paragraph number 7, Om Prakash versus Dwarka Prasad.
It's a case under the CPC.
CPC, Your Lordship, but it was inside that there's a discussion, Your Lordship.
Just a moment.
From para number 7, Lordship, para number 7, 8, 11, 12, may I read, Lordship?
Just a moment. Let us go to the statute first.
And there is an inherent power by this honorable court, Your Lordship, which is section 582 in saving of inherent powers of the High Court, Your Lordship. By invoking this inherent power, this honorable court can be treated this appeal as a revision petition.
What is the statutory provision in this regard?
My lords, if I may,
Lordship, 582 of the BNSS, Lordship.
your lordships, if I may, I'm sorry, I have to interject, my lords, because we have to come clean with the provision of law. Your lordships' query yesterday was, can we treat this appeal as a revision?
Yes.
My lords, I had submitted before your lordships that, my lords, a revision can be treated as an appeal under 442 of subsection 5 of BNSS, but not the other way around, my lords. Your
Because there is no similar provision.
No, my lords. A revision may be treated as an appeal, but not the other way. 444, section 442, subsection 5.
Lordship, a revision can be treated as the appeal and vice versa.
The statute doesn't say so, at least.
Lordship, yes, that which I have relied upon, Lordship.
Yes. Unfortunately, it is under the CPC.
Lordship. May I read, Lordship? Paragraph number 7, relevant is paragraph number 7, 8. Lordship may be very much familiar with this. And since it is a procedural error, Lordship, so it doesn't change the fundamental nature of the case if this appeal can be treated as the revision petition. So the mistake committed by the learned trial court was very clear. So whatever the discrepancies reflected in the impugn order was clearly annexed in the final complaint, and that was a mistake committed on the part of the trial court.
No, well, see, this, I am trying to find out if there is reference to any criminal matter in this case. Because CPC there is 151, under that
151.
certain powers are there.
Lordship, yes.
This is a criminal matter,
criminal
and the
matter.
specific provision has been made.
Lordship, it's
In the CPC there is no similar provision saying appeal can be treated as revision or anything like that. So this is in exercise of inherent powers under 151.
Lordship, yes.
But in the case of the CRPC or BNSS now, things are different.
528 is
There is a
available.
specific
Lordship,
provision.
yes, I understand. Unfortunately, this one is come under the CPC. Lots of other provisions are also there. Other citation is also there, which come under the CRPC also. But unfortunately, today, mistakenly, I was not with me.
Your Lordships, my Lords, today I am a legal aid counsel to assist your Lordships. On merits, my Lords, he may have a case. Insofar as this maintainability aspect, your Lordships, I have shown your Lordships 442 subsection 5. Now, my Lords, assuming your Lordships, there is some precedent in his favor that you can treat this appeal as a revision. Under section 131 of the Limitation Act, my Lords, I'm sorry, article 131, 90 days is the limitation for preferring a revision under the CRPC. So, my Lords, this 90 days has long gone, because I believe this was filed sometime in 1st July of last year. Not, therefore, if your Lordship saw that the earlier order passed by Honorable Justice Shamima, there was whether the question of maintainability on whether application for condonation is also need to be filed in this. This has not been done. So, my lords, there is some. I would say
Let's get over the first barrier.
Yes, my lords.
That is whether it can be converted. At prima
Yes,
facie, it
yes.
doesn't appear to be so. In
And
the-
Your Lordship, this, because the condonation for filing appeal and revision is 90 days.
Yes.
And it's within time, Your Lordship. So there is no delay on the part of the petitioner, Your Lordship.
So when was the impugned order passed?
Impugned order was passed on 4/7/2024, and this petition was filed within time.
This was filed, but now if we dismiss it as non-maintainable, you have to file a revision.
A
Then
revision, Lordship.
where
So
is that
it-
90 days?
Yes, that is the issue. So this honorable court has an inherent power. If this honorable court can convert by exercising this 528 inherent power of the High Court, then it's not barred by the limitation.
It's not inherent power. There is a provision in the Limitation Act. If you are bona fide litigating in a court without jurisdiction, then that period can also be condoned. So let us, you can withdraw this and file a
Withdraw and file
revision.
afresh. That is one of my basic instincts, Your Lordship.
Since we had time, we carried out an academic exercise
Very true, Lordship.
on the prayer of learned counsel for the petitioner. This appeal is allowed to be withdrawn. Petitioner shall be at liberty to prefer appropriate application challenging the impugned order herein, subject of course to limitation. Appeal stands dismissed on withdrawal.
My lords, just one
Much obliged, Lordship.
where legal aid counsels, my lords, there is a
All right.
Yes.
registry may do the needful.
Name, he appeared. Both record, both of them. Him also.
No, my lords, it will just be legal aid. It's a private appeal
Oh.
by the department, so it will only be for the legal aid.
I'm not legal aid. I'm a special PP for the.
No, that's okay. I'm saying for the petitioner he is appearing.
Yes, yes,
That,
yes.
that
I'm
is to be
sorry, I'm sorry.
reflected.
Obliged.
Item 12.
Keep it in my chamber.
My lord, we have served the respondent the copy as well as the order through Talabana and Tasti, but still no respondent has been.
But what is this IA for?
The first one is for condonation of delay.
Okay.
This 120 days.
That is application number 151.
Yes, my lord.
No, this is your affidavit of service. Okay. Isn't it? Okay, in 151. Right. Heard learned counsel IA 151 of 24 in RFA 32 of 24. Heard learned counsel for the petitioner. The sole respondent has been served. But none appears to represent the said respondent. This is an application under Section 5 of the Limitation Act, read with Order 41, Rule 3 SCPC, for condonation of a delay of 120 days in preferring the connected RFA. On perusal of the reasons mentioned in the instant application for the delay of 120 days in preferring the instant appeal, connected appeal, the same are found to be sufficient and valid grounds for condonation of the aforesaid delay. Accordingly, the prayer is allowed. The delay in condonation, delay in preferring the connected appeal is accordingly condoned. I stance disposed of. List the appeal for admission after 2 weeks.
Item 13.
My Lord, notice is complete in this case.
My Lord, I'm the standing counsel for the respondent number 5. And however, my learned friend has gone through all the trouble of taking justice service when she can simply serve me a copy. So if my appearance can be reflected in the court, yes, my Lord.
I'd learned counsel for the petitioner. Mr. So-and-so appears on behalf of respondent number 5 and
Hearing for respondent number
1. So what about the other respondents in between?
1. They are the state 2 to 4.
Respondents 2 to 4 are represented by the government advocate. So this was for orders. Is it?
Yes, orders.
Release the matter for admission after 2 weeks.
Obliged, my Lord.
As well as
Item 14.
My Lord, paper book has been prepared and we have received. So the matter may be listed for hearing.
Heard learned counsel for the petitioner and learned public prosecutor. It is submitted that paper book is ready and furnished.
Yes.
yes.
Ready and already furnished to the parties. List the matter for hearing after 4 weeks.
Obliged.
Item 15.
Lordship, I'm for the respondent number 2, and I'm seeking time, 2 weeks time to submit objection for the IA.
IA is for what, condonation?
Yes, Your Lordship.
How many days?
130 days.
The time granted to you for filing objection is greater than the delay in referring the application. Right in the IA, heard learned counsel for the petitioner. Learned counsel for the state prays for further time to file objection. It's the one perusal of the order sheet. It appears.
State will not be filing any objection.
Who are you?
Respondent number 2.
Heard learned counsel for the state who submits that state will not be filing any objection. Prayer has been made on behalf of respondent number 2 for further time to file objection. On perusal of the order sheet, it appears that sufficient time has already been granted for the said purpose. And no further time is granted. Where have you given the reasons in paragraph?
Lordship, starting from para number 1, starting from Roman number A, small letter A.
Para having, there is the reason cited, that last one, no? Same order, okay. Just you mentioned the paragraphs 1, B, C, D, E, F, and G, okay, of the I.
Lordship, if a fixed date can be given.
Yes, list the connected criminal revision petition on
2nd September, Lordship.
Okay.
Item 16.
Lordship, I'm for the respondent number 1, and I'm seeking another time, 2 weeks' time.
My Lord, on the last occasion, I was instructed to take steps with regard to respondent number 3. On the previous court date, my Lord, I took steps. However, my Lord, it has returned unserved. So, my Lord, I may be kindly allowed to take new steps by way of dusty service, my Lord. By way of
Third
dusty.
learned counsel for the petitioner. It is submitted that pursuant to order passed dated 15/7/25, a petitioner has taken steps, but upon respondent number 3, but AD card has not been received back, and prays for effecting dusty service upon the said respondent number 3. Prayer is allowed petitioner to take steps within 3 days, at least after 2 weeks.
Obliged.
Item 17.
May it please, my lords. My lord, on behalf of the state respondent, we would like to file a objection to the IA, my lord. If your lordship can grant us a week's time. The IA is for substitution, my lord.
Substitution on account of death.
Yes, my lord.
Yes,
How can there be an objection to death?
Because at the time of filing WPC, the husband had already passed away, my lord.
So dead man filed a WPC.
Yes, my lord. That is what. That is why we would like to file our objection, my lord.
All right, this would be interesting.
Yes, my lord.
On the prayer of learned counsel for
The state respondent.
state respondents, 2 weeks' time is granted to file affidavit. Objection.
Obliged, my lord.
List after 2 weeks.
Item 8.
Is here.
Lordship,
You
as
are
per the-
appearing? Not yet.
She is still on legs. However, I have some on item 8, my lord. If both parties agree, then it can be sent for mediation.
All right. What do we have here? Mediation center. What? Huh? How is it sent? Yes, yes, I know. Yes. Okay. So we just send it to mediation center. Yes. Any form is required to be submitted. No? All right. Has any similar order been passed earlier? Okay, we'll pass the same orders that is passed in other cases. Okay. Just check it out. We have to fix a date for appearance, I think. Or they will receive notice. Okay.
Item 9 and 10.
Much obliged.
Same, I think.
9 and 10, my lord, we have not received Parawai's comments. That is the instructions I have received. However, looking at the orders, my lord, it seems that the learned GA has to get instructions whether the instant cases are covered matter or not. So I have
No, time was for all three items were passed over. I thought these were similar matters. This is different. It has nothing to do with mediation.
this is not for mediation.
My lord, here earlier order was passed on 26 June, stating the stand taken by us is that the instant cases are covered matter. Earlier order was passed by the coordinate bench of this court in respect of writ petition number 26 2023 and 125 of 2021. So this order also covered.
So that is the instruction that was required to be submitted?
Yes, that is
yes.
Your Lordship, I am appearing on behalf of the state respondents. I am yet to receive instructions as to whether this is, if at all it is a covered matter. So if I may be given another 2 weeks time to gather the instructions, Your Lordship, from the state respondents.
See, if it is a covered matter, all you need to do is get hold of the order passed in the earlier case and compare it with the present petition if it is there.
Yes, Your Lordship, and also I have to get the instructions from the department as well, Your Lordship, because they may not factually differ from, they may actually factually differ from the said previous judgments, Your Lordship.
Okay, how long do you need now?
Your Lordship, if 2 weeks time may be granted, Your Lordship.
All right, heard learned counsel for the petitioner. On the prayer of learned government advocate, further 2 weeks time is granted to obtain instructions as to whether the present writ petition is a covered matter. Full stop. List after 2 weeks.
Much obliged, Your Lordship.
Same, 9.
Yes, Your Lordship. 9 and 10, Your
9
Lordship.
and 10.
Hearing list, item 1.